everyone, and welcome again to FYI Academy, the place where you can learn, grow, and connect at FYI. And today we have a wonderful presenter, our own employee, Joe Kelly, who is an attorney who specializes in labor and employment law. He works for FYI as a labor relations specialist at U.S. Department of Labor, and he's been with us for 8 years. I would like you to welcome Joseph Kelly. I don't think we can hear you, Joe.
Can you hear me now?
Yes, I can hear you now.
Okay, great.
All right, so share my screen.
So we have a 281.
If I can ask you, please kindly mute yourself.
Yeah, that includes the.
Thank you so much, guys. Can you see my screen?
Yes.
In the slides? Okay, perfect.
Do you want to put it in like the presentation mode so we just see the slide, each slide?
There you go.
All right, and with that, we'll go ahead and get started. Thank you, Anya, for that introduction, and thank you, FYI, for having me teach an FYI Academy session. I appreciate the opportunity. And today's session is going to be an introduction to federal sector labor law, part 1, the functions of the Federal Labor Relations Authority. Next slide, please. So here's a roadmap of the questions that I'm going to try to answer for you all today. What is federal sector labor relations? What is the Federal Labor Relations Authority? What are the functions of the Federal Labor Relations Authority? And then we'll have questions and hopefully answers if we have time. So I guess before we dive in, I would just like to say that I know that this, so I struggled a little bit with what information to include, how much information to include, and how to organize it, because the topic of federal sector labor relations is pretty deep, and it's pretty squishy in that terms are very often ill-defined, not defined very well. It's nuanced and complicated. There are a lot of sort of rules and circumstances that may apply in certain cases, and there's a lot of uncertainty in federal sector labor relations, especially when you're going before a third-party neutral, like an arbitrator. You have no idea what the outcome of your case is going to be, and so for those 3 reasons, getting your head around federal sector labor relations for the first time can be challenging. So I did my best to organize this information in a way that sort of makes sense for folks who haven't been exposed to it for very long. And just to inject a little bit of maybe fun into it, I'd like to give you the top 3 things about myself that you probably need to know while you're watching me present. And that is, number 1, I'm a huge bicycle enthusiast. I ride my bike everywhere. I commute to work on a bike. I run my errands by bike. And I even got rid of my car a couple years ago because I got sick of sitting in traffic, and I was driving so infrequently that it became more of a hassle and an expense than a utility for me. The second thing is that I love my cats. I rescue cats, and right now I have 2 in my house. Their names are Foxy and Baby Boy. and they're alley cats, so they're scavengers and they have no manners whatsoever. But they're a lot of fun, and they really enrich my life, and I really appreciate them in my house. And the last thing to know is that I have a moderate to severe case of imposter syndrome. Uh, so, I was excited when FYI approached me about doing an FYI Academy session because that's an opportunity for me to sort of chip away at that feeling that I'm sort of faking it till I make it. And if any of you out there have experienced imposter syndrome, you know the feeling I'm talking about. Okay, so let's dive in. The first question I want to answer is, what is federal sector labor relations? And here's a definition you might find online, or it's the system governing labor management relations between the federal government and federal employees under the framework of the Federal Service Labor Management Relations Statute. So I don't care very much for that definition. I don't think it's particularly helpful, especially if you haven't been exposed to labor relations and you don't really have a context for what that means. Next slide, please. So then really, what is federal sector labor relations? I think a better definition, and this is my definition, it's the process giving federal employees the right to join a union, to engage in collective bargaining. I'm sorry. Okay, sorry about that. It's the process giving federal employees the right to join a union, to engage in collective bargaining, and to participate in decisions affecting employment. Next slide, please. So then what is collective bargaining? So collective bargaining is defined in the Federal Service Labor Management Relations Statute as the performance of the mutual obligation of a representative of a federal agency and the exclusive representative of employees in an appropriate unit in the agency to meet at reasonable times and to consult and bargain in a good faith effort to reach agreement with respect to the conditions of employment affecting unit employees, and to execute, if requested by either party, a written document incorporating any collective bargaining agreements. And I'll stop there. The statute actually goes on from there. And I read that as it's written to point out that that is a terrible definition. It's one giant run-on sentence with so many prepositional phrases. It makes my head spin, and I don't think it's a helpful definition. Next slide, please. So then really, what is collective bargaining? And I would say that collective bargaining is when federal agency management and a union get together and negotiate in good faith over the conditions of employment that affect that agency's employees. And there's some nuance to that, but I don't think this is quite the place to get into the nuance, because I wanted to keep it at sort of an introductory level for those who haven't had much exposure. Next slide, please. So then, what is the law governing federal sector labor relations? So I mentioned the Federal Service Labor Management Relations Statute. For those of us in the in-group, we refer to it as the statute because it's kind of a mouthful. It's not a snappy acronym, and it's just easier if we refer to the statute. And you can find the U.S. Code at 5 U.S.C. 7101 through 7135. Next slide, please. So then what does the statute say? The statute establishes the right for most federal employees to organize and participate in a union, to engage in collective bargaining, and to negotiate over working conditions. It's a fairly short statute, and that's basically what it does. And it offers various processes and various ways to resolve different disputes that arise in federal sector labor relations. Next slide, please. All right, so who administers the statute? that would be the Federal Labor Relations Authority. They're the agent, they're sort of a boutique agency. They're a very small federal agency. They have about 116 full-time employees across 7 regional offices in the U.S. and headquarters here in Washington, D.C. And as many of us know, federal agencies are often huge. Department of Labor is a very large federal agency, and in comparison, the FLRA is quite tiny. And the FLRA is charged with making rules and developing processes to enforce the statute. So next slide, please. Okay, so the mission of the FLRA is to promote stable, constructive labor relations that contribute to more effective and efficient government through the administration of the statute. So these, labor laws in the United States came out of labor unrest in the early 20th century, in the mid part of the 20th century. And Congress decided to pass laws giving labor unions certain rights in the workplace to sort of quell the labor unrest that was going on all over the country. And Congress's hope was that by providing labor unions with sort of a framework and certain rights, that would quell the unrest and the agencies could function properly without a lot of the distractions caused by an unhappy workforce. Next slide, please. So who does the FLRA serve? So they administer programs for about 2.1 million federal employees. It serves both unionized and non-unionized employees. For the unionized employees, they have about 1.2 million federal employees across 2,200 different bargaining units or unions. Next slide. Okay, so here we're starting to get into the meat of what the FLRA does. So the FLRA has 5 primary responsibilities. They resolve unfair labor practice charges. They determine appropriate bargaining units for unions in the federal workplace. They decide appeals of arbitration decisions. They also decide negotiability cases. And then additionally, they resolve negotiation impasses. And they have specific rules and procedures for each of those primary roles. And we're going to go through those as we go on. Next slide, please. Okay, so we're going to start with unfair labor practices. Next slide, please. So generally, an unfair labor practice is conduct by either an agency or a union that violates a right that's protected within the Federal Service Labor Management statute. So some examples of a ULP and the conduct that gives rise to a ULP, or the conduct that constitutes a ULP, is found in the statute itself. I didn't list every single possible ULP that the statute mentioned, because many of them, the wording is awkward and they don't necessarily make a lot of sense without context and background and knowledge of the area of law. So, I wanted to keep everything sort of on an introductory level. So I wanted to give some examples of unfair labor practices that are provided in the statute. Discriminating against an employee due to union activity. So that might be a supervisor who was unhappy that one of their employees is a union steward or a union officer, and then rates that employee poorly on their next performance appraisal because the supervisor is unhappy that the employee is involved in the union, because maybe the supervisor doesn't like the union, maybe the supervisor has problems with other people in the union. Whatever the case may be, it's an unfair labor practice for an agency to take action against an employee because of their union activity. Refusing to negotiate in good faith is also an example of an unfair labor practice by an agency. The agency and the union could be negotiating a new main agreement, a main collective bargaining agreement. They could be negotiating a memorandum of understanding regarding maybe an office move or a change in personnel policy that the agency wants to institute. But where there are negotiations going on between the agency and the agency and the union, it's an unfair labor practice for the agency to not negotiate in good faith with the union. Threatening employees to discourage membership, making them fear for their jobs, or threatening to withhold a performance bonus, or threatening to downgrade their rating because they're doing too much union business, even though that's not directly affecting their performance. Those types of threats are considered an unfair labor practice. Making changes to employees' working conditions without notifying the union. Going back to the example of changing a personnel policy, for example, the number of days that employees need to report to work on site, that change is made without notifying the union, then that's an unfair labor practice. Failing to cooperate with impasse procedures by the Federal Labor Relations Authority, and we're going to get to that down the road here in a little bit. That's an unfair labor practice, and you can find more more unfair labor practices in the U.S. Code in the statute at 5 U.S.C. 7116. Next slide. Okay, so then those are unfair labor practices by the agency, but what about the union? Because the union can commit unfair labor practices as well, and it's a two-way street. So a union cannot discriminate against an employee in the context of union activity due to that employee's protected class, such as race, national origin, sexual orientation. That's an unfair labor practice. Refusing to negotiate in good faith with the agency, that's also an unfair labor practice. So that cuts both ways as well. And if you've ever been at the bargaining table with the union, you know that there are times when neither party behaves in the best light. So I think it's good that ULPs go both ways as far as negotiating in good faith. Refusing to cooperate in impasse procedures. Once again, the union's obligated to cooperate. And going on strike is also an unfair labor practice. Congress afforded federal employees all sorts of rights, procedural rights and substantive rights in federal employment. But one thing they don't allow is for federal employees to strike. It's unlawful to strike, and it's an unfair labor practice if they do. Next slide, please. So who can file a ULP charge? A union can file a ULP charge. An individual can file a ULP charge against a union or against an agency, and an agency can file an unfair labor practice against a union. Now, the vast majority of unfair labor practice charges come from unions against the agency. Even though the agency has the ability to file unfair labor practices, you really don't see that very much. And that's probably because of sort of the power dynamic between management and the union. Obviously, management has a lot more power and probably has less of a need to hold the union accountable when they engage in the types of conduct that give rise to unfair labor practices. But I am aware of one time at DOL when management filed a ULP against the union. And immediately the political pressure came on senior leadership, and the ULP was immediately rescinded by management. It was withdrawn. That's not to say there wasn't any merit to it. And this was over a bargaining in good faith issue. And so the ULP, the withdrawal of the ULP isn't to say that the ULP charge had no merit. It's just to say that it created a very bad look for the Department of Labor to be filing charges against its internal unions. And so that political pressure, forced them to withdraw the unfair labor practice charge. So the process for filing a ULP charge, you're going to file in the FLRA region where the violation occurred. So we've got 7 regions and a headquarters, and the regions are geographic. And so you find where the violation occurred, whichever geographic region that's in, that's the FLRA office that you go to file the charge. You have 6 months from the date of the violation. In some cases, there may be circumstances where a charging party isn't aware of the unfair labor practice until after the 6-month time frame has passed, and as long as it's newly discovered, like they had no reason to know that it was an unfair labor practice, then they have 6 months to file from the date they became aware of the violation. Again, as long as they had no reason to know of the violation when it occurred. And so in the ULP charge, the charging party is going to include a brief statement of what happened, facts and allegations. They're going to include witnesses and, people and parties involved so that they can be contacted by the FLRA. And the charging party is also going to include any supporting documentation that goes to the fact that a ULP did in fact occur. Next slide, please. So what happens after a charging party files an unfair labor practice charge? The respondent, in this case, I'll say it's an agency because it's usually an agency, is the responding party. The agency is the one receiving the charge from the union. The respondent agency receives a copy of the charge at the time that it's filed. The respondent then should begin gathering evidence and developing any defenses it might have, and start pulling together its side of the story that it wants to give to the FLRA to rebut the charge. And it should include a list of witnesses and people involved, just the same way the union included a list of witnesses to the incident and any people involved. The agency should do that as well, so that FLRA can fully investigate. And the respondent, and again, in this case, the agency has 20 days from the time they receive the charge to submit their statement of position to the FLRA. And they should also obviously include any supporting documentation that would indicate that a ULP did not occur. Next slide, please. Okay, so what happens after the agency files its response to the ULP charge? So the FLRA will first review the charge for sufficiency to make sure that on its face, it could be an unfair labor practice charge. If all the evidence, plays out to that effect. So the charge needs to be sufficient on its face that this could constitute an unfair labor practice if what they're saying is true. So then if the FLRA finds a charge sufficient, then they move to the investigation stage where they investigate the charge. They review the documents that both the union and the agency provided. They interview the witnesses that both the union and the agency provided. And they may even speak to people who are involved. And the FLRA will independently gather any evidence that refutes the charge. They're purportedly a neutral body, and so they are looking for evidence that there was a ULP, and they're also looking for evidence that there was not a ULP. Next slide, please. So then after the investigation, the FLRA has done its investigation, and then they determine whether there's any merit to the charge. They determined in an earlier phase that the charge is sufficient on its face, but now we move to the stage where does the evidence support the charge? And if it does, then the FLRA will issue a complaint and a hearing will be scheduled with the judge. And if the charge does not have any merit, if the evidence does not show that there was a ULP, then the charge will be dismissed. If if there are multiple charges between two parties, the FLRA can issue a complaint on some charges while dismissing others. It just depends on what the evidence dictates. The parties can settle at any time. The FLRA loves for the parties to settle, and they never stop strongly encouraging. I might even go so far as to say arm twisting parties to settle disputes because it makes the FLRA's life a lot easier. And they prefer negotiated agreements to forced resolutions on any given dispute. They would rather the parties reach agreements and then everybody gets to wash their hands and move on to the next dispute, right? So in addition to settling, a charging party can change their mind and withdraw the charge at any time. At any time in this process, they can just decide that they no longer want to pursue it and they can just withdraw the charge. And then once again, the parties wash their hands and walk away to the next dispute. Next slide, please. Okay, so at a ULP hearing, the hearing with the judge, and this is an administrative law judge. It's not the same judge you would go before if you were going to, traffic court or federal court or some other kind of court system. This is an administrative law judge, and they're scheduled. The hearings are scheduled usually within 2-3 months after the FLRA issues a complaint on the ULP. And the administrative law judge, holds a full hearing. They receive evidence and they take witness testimony. And once the judge renders a decision, they send that decision to the FLRA as a recommendation. They don't, so they issue a decision about what their assessment is, but that decision is not binding on the parties. The decision goes to the FLRA, who then reviews the administrative law judge's decision to decide whether or not the FLRA agrees that there was a violation. And if the FLRA does find a violation after, pursuant to the judge's report, then the FLRA will issue relief. Next slide, please. Okay, so let's say the FLRA is giving relief to a charging party over a ULP. So what does that relief look like? Typically, they give make whole relief, which just means that you completely restore the employee to the position that they were in before the unfair labor practice. And so make whole relief could be reinstatement if the unfair labor practice is a removal of a federal employee. It could be back pay if the unfair labor practice was an unjustified suspension without pay of an employee. The FLRA will order that the agency rescind the action that gave rise to the unfair labor practice. And the remedy or relief that agencies hate the most is sort of the most innocuous one, and it's the posting notice. This one doesn't cost any money to the agency the way a back pay award might cost the agency money. It's just that the FLRA orders the offending party to prominently display a notice on its premises and online that it violated the law, and the agency promises not to do it again. And so that it's like getting a spanking, and they really, really don't like having to put up a notice for all their employees to see that they violated the law, and then they have to promise not to do it again. They really do not like that, but that's for more, I guess, psychological reasons than pocketbook reasons. Next slide, please. Okay, so let's talk about bargaining unit determinations. That's the second function of the Federal Labor Relations Authority. Next slide, please. So what is a bargaining unit determination? A bargaining unit determination is the process used by the FLRA to determine which employees should be included in a bargaining unit. That's a pretty straightforward definition, I think. Next slide, please. So then that definition leads to the question, what is a bargaining unit? And the answer is it's a group of employees with a shared interest in wages, hours, working conditions based on the nature of their job duties and their quote unquote community of interest. And so for example, you might have a group of employees who want to form a union. And so the FLRA's question in determining their bargaining unit is whether these employees are a group of people for which it makes sense to lump them into a group to allow them to collectively bargain their conditions of employment with their employer. So for example, at DOL, in the wage hour division, we have wage hour investigators. And all the wage hour investigators, they share a common interest in working conditions. They have similar or the same job duties. They're working toward the same goal. They work in the same office. And so they have a certain community of interest. And the Federal Labor Relations Authority at one time back in the way past, before I came around, the FLRA determined that wage hour investigators was a group who should be lumped together for collective bargaining, and determined that they should be a bargaining unit themselves. And the bargaining unit is abbreviated by the letters BU. So in the business, we don't call it a bargaining unit determination, we'll call it a BU determination. Or we might refer to BUE, which stands for bargaining unit employee, instead of saying the entire phrase, which is a little bit of a mouthful and kind of unnecessary. Next slide, please. So what is the process for determining a BU at the FLRA? So the party that is seeking to resolve a dispute over what the correct bargaining unit should be, files a petition with the FLRA. Then the FLRA reviews the petition, and just like any petition, you need to set forth your case in the petition and include reasons why the proposed bargaining unit makes sense. And that's really what determining the bargaining unit comes down to, whether it makes sense to put all these employees together in the same bargaining unit to collectively bargain their terms and conditions of employment. Next slide, please. So after a petition for a BU determination is filed, the FLRA, if it chooses to, it'll issue a notice of investigation to look into the matter, because it wants to investigate and make that determination. And in that notice of investigation, it will outline the issues that it needs to resolve. And those issues might be, do the employees really have a shared community of interest? Are they performing the same functions? If they're not performing the same functions, are they performing functions that are similar enough that that it makes sense to put them in the same bargaining unit? The FLRA may ask the petitioner and the other parties involved to provide data and make their arguments, give their positions, and provide any additional evidence that would go to whether this group of employees should be considered a singular bargaining unit. And if the FLRA decides that they're not really into it, they can dismiss the petition and just and choose not to grant the bargaining unit determination. Next slide, please. So what happens if there's an investigation into the bargaining unit petition? So the FLRA gathers more data, it interviews more people, and it reviews more documentation to fact find and gather enough evidence to make that determination of whether it makes sense to lump these employees together. The FLRA regional director makes the decision on these investigations, and they decide whether to approve, modify, or reject the proposed bargaining unit. So you'll note that the option to modify is in there. So if the regional director determines that it's not this isn't quite the bargaining unit, but if we tweak it just a little bit, then that'll be an appropriate bargaining unit. That's an option that the regional director has. And then the FLRA reviews the regional director's decision to affirm or deny it. And if the decision is affirmed, then the FLRA certifies the bargaining unit. Next slide, please. So if the FLRA certifies the bargaining unit, then the collective bargaining can begin. That is the first step toward negotiation of a collective bargaining agreement, is once the FLRA makes that bargaining unit determination. And any further disputes that arise about the bargaining unit, whether it's appropriate or not, the FLRA will handle those as well. Next slide, please. So arbitration appeals. So this is my main bailiwick at the Department of Labor. I'm involved in all these various stripes of dispute that we're talking about today, but arbitration is the one that I do the most, and it's the one that I like the most. And just to note that we don't call them appeals. I'm using the word appeal here because I think it has more sort of, it's a better term here when we're at the introductory level. In the business, we call it filing an exception. I prefer to just say appeal the decision. But this is the third function of the Federal Labor Relations Authority, is to make decisions on arbitration awards. Next slide, please. So what is arbitration? So it's a dispute resolution process where the union and management get together and they bring in an impartial third-party neutral to act as a judge who makes a binding decision after holding an evidentiary hearing. So it's very much like court light. That's how I like to refer to it. It's similar to the courtroom in your imagination that you picture. You've got the arbitrator who is serving as the judge, and he's in command of the process, and he makes rulings on objections and questions about evidence. And the parties sit at opposite tables, and they get the opportunity, they each get a full opportunity to make their case, submit evidence, call witnesses, cross-examine witnesses, and make opening and closing arguments. And at the end of the hearing, the arbitrator will make a binding decision the same way a judge in state court would make a binding decision after a hearing. And the specific processes followed in the arbitration proceedings are outlined in whatever collective bargaining agreements the parties have. So each arbitration procedure can be different, but it has to be memorialized in the parties' collective bargaining agreement. Next slide, please. So to an appeal and arbitration award, either party can appeal if they're unhappy with the arbitrator's decision. But I would caution that just being unhappy with the arbitrator's decision is not enough justification to appeal that decision. The grounds for FLRA review are very limited, so agencies should be cautious about which cases they appeal. They need to have grounds that fit in the FLRA's jurisdiction to review arbitrator awards. And those grounds are, it's got to do one of four things. It's got to either violate federal law, it's got to violate a previous FLRA ruling or an FLRA rule. It's contrary to the parties' collective bargaining agreement, or the arbitrator's award violates public policy. If any of those four issues are the case, then the FLRA has jurisdiction to review the award. And next slide, please. So how does the FLRA review arbitration awards? So the appealing party submits a petition for review, or I'm sorry, not a petition for review. They submit exceptions, And then the FLRA conducts an initial review. The FLRA can deny, they can grant it, or they can send the case back to the arbitrator for further proceedings. The FLRA issues a decision stating its conclusions with legal support, and that decision is binding. And the FLRA can uphold, modify, or vacate the arbitrator's award, in addition to remanding it back to the arbitrator, which means sending it back to the arbitrator with instructions to engage in further fact-finding or do something a little bit different than they originally did to arrive at their award. Next slide, please. So let's talk about negotiability disputes. This is the fourth function of the Federal Labor Relations Authority. Next slide, please. So a negotiability dispute occurs when there's a disagreement between an agency and a union about whether a particular bargaining proposal is negotiable under the statute. I think that's a decent definition. Next slide, please. But really, what is a negotiability dispute for folks who aren't sort of steeped in all this, like myself, and some of you on the call here? In simpler terms, the union proposes a provision it would like to see in the collective bargaining agreement, whether that's the main collective bargaining agreement or memorandum of understanding that they're engaged in for midterm bargaining, whatever they're bargaining. The union proposes a provision that it would like to include in that agreement. And then the agency refuses and asserts that it is non-negotiable because the proposal conflicts with existing law, existing regulation, or some enumerated management rights under the statute, which I will address in a future presentation. Next slide, please. So the union will submit a proposal during so the mechanics of this is that the two parties are at the bargaining table. The union submits a proposal during the collective bargaining process. The agency decides that the proposal conflicts with the law or management's rights, and they believe that the issue is non-negotiable, that they don't even have to entertain the union's provision. And once the agency makes that declaration, the union then files a negotiability appeal with FLRA to request a ruling on whether or not the union's provision is negotiable or not. Next slide, please. So then the process for the negotiability dispute, once the FLRA gets it, the union files its petition with the FLRA within 15 days of the agency raising its negotiability issue. So that once the agency declares the proposal to be non-negotiable, the union has 15 days to file a petition with the FLRA to address the matter. Once the petition is filed, the FLRA will call for a post-petition conference to gather more information from both parties. Both parties attend along with an FLRA agent, and they sort of bring together all their arguments and evidence and sort of lay everything out on the table. No decision is made at that conference. It's just a venue for the parties and the FLRA to gather more information about the parties' positions and any evidence that supports those positions. So then after the post-petition conference, the agency will submit its statement of position and any evidence to support its statement of position. And then once the agency submits its statement of position, then the union submits its response to the FLRA. And then after the union issues its response, the agency gets one more chance and can issue a reply to make any further arguments that it needs to make based on the union's response. Next slide, please. So the possible outcomes of a negotiability dispute. So after the FLRA reviews all the information and decides whether the agency is actually required to negotiate over the proposal or not, the FLRA will make a determination, and it will either find the provision negotiable, in which case it will force the agency to negotiate, or it will find the proposal non-negotiable, which means clearly the agency does not have to negotiate. And one important note is that a finding of negotiability is not the same as finding that the provision is proper or appropriate or correct or should be agreed to. It's just a finding that the provision that the union put forward should be negotiated. That doesn't mean it needs to be agreed to. The agency could ultimately not agree to the proposal, but the agency does have to at least negotiate over it if the FLRA finds that the proposal is indeed negotiable. Next slide, please. And the fifth and final function of the Federal Labor Relations Authority is resolving negotiation impasses. And these negotiation impasse, well, next slide, please. I've got the definition on the next slide, so I'll just hold my horse there. So a negotiation impasse occurs when the agency and the union are at the table bargaining to reach an agreement, and they can't reach agreement on the terms of what they're bargaining. They're just stuck. They've run out their attempts to persuade each other, and nobody's willing to make any movements. Next slide, please. So what is the negotiation impasse process at the FLRA? So if the parties can't reach agreements, either party can request mediation with the Federal Mediation and Conciliation Service, also known as FMCS, and that's an office within the Federal Labor Relations Authority. So they request mediation help from FMCS. Next slide, please. So there are going to be times when mediation does not resolve the impasse. I would venture to say that it's more often than not that mediation does not resolve an impasse. A mediator's job is to facilitate agreements, and the mediator doesn't have any authority to force the parties to agree or to force anything on the parties. So the mediator is just trying to help the parties come to an agreement. And if the parties are so far apart that they're not going to reach agreement, there might not be much the mediator can do in that situation. So if mediation fails, then the case goes to the Federal Labor Relations Authority. FMCS is an office within the FLRA, but now the case goes to the authority itself, the FLRA, for a determination of whether the FLRA wants to take action on the impasse. And if it does want to take further action, it can appoint a fact finder who investigates the dispute and offers the parties non-binding recommendations for resolution. So much like the mediator, the fact finder can't force the parties to do anything. They're just trying to get to the bottom of the dispute and help find a way forward. Next slide, please. All right, so if, like I said, if the mediation doesn't resolve the impasse and the fact finder can't resolve the impasse, the FLRA intervenes. FLRA can choose to engage in more mediation efforts if it believes those might be successful, or it can appoint an arbitrator to resolve the impasse. And arbitrators issue binding decisions. So if the FLRA goes with a mediator over an impasse, there's going to be more facilitation of an agreement and sort of less force used by the FLRA, because we're still just trying to get the parties to reach an agreement on their own. But if the FLRA goes with an arbitrator to resolve an impasse, the arbitrator is going to hold a hearing and then issue a binding decision, just like a judge would issue a binding decision in court. So the arbitrator's decision forces the parties in a negotiation, in a bargaining impasse, it forces the parties to adopt specific language in their agreements. And even though the arbitrator forces the language on them, the parties can't, they don't have a say. If the arbitrator decides what language they want to see the parties use, the parties don't have any say. They've lost control over the outcome, and they must adopt the language that the arbitrator decides is appropriate. And that language is then considered to be agreed upon. So even though it was not agreed upon, and it wasn't anywhere close to agreed upon, and that's why there was an arbitration in the first place, because the parties were so far apart, couldn't reach agreement. The law deems the arbitrator's language to be an agreement that the parties must honor. And if they don't honor it, it's an unfair labor practice. Next slide, please. So now is the time where I can entertain any questions and hopefully provide some answers. So with that, I'll open up the floor.
Hi, Joe. This is Anya.
Hi.
What was the most interesting case, if you can share, of course, in
So
your
probably,
practice?
yeah, so probably the most interesting matter I've dealt with in a while is all of the issues around the return to the office from telework. So DOL had been in a maximum telework posture, meaning everybody was teleworking all the time for several years because of the COVID pandemic. And then they started bringing in people 2 days a week. And then after a couple of years of that, the department decided it was time to bring back people 5 days per pay period. So people need to be coming into the office half the time that they're working. They can telework from home half of the pay period, but they need to be in the office for the other half of the pay period. And as you might expect, all of the DOL unions were screaming bloody murder. They're all very unhappy about it. And of course, as somebody who appreciates the comforts of telework, I can certainly understand their position. But because my role is to represent management in these disputes, I take their side on the question. But there has been so much activity from all of the DOL unions. There have been unfair labor practice charges. There have been grievance arbitrations. There was a bargaining impasse when management first notified the union that they were going to start bringing people back. The union started using all these tools that the FLRA has, going through all the functions and sort of appealing to the FLRA to get involved. The union claimed that the parties were at a bargaining impasse when they were not really at a bargaining impasse. Management, the union put forth some proposals that sort of negated the ability of the office, the ability for management to bring employees back into the office, and management declared those proposals non-negotiable. So then they reached back out to the FLRA for a negotiability dispute, and then and so there's just been and I can see my colleague Lou Hoffman is on this call, and she has been working with me, and we have been tirelessly trying to make the case that the department has the right and the ability to bring folks back into the office after they've been
I wouldn't say tirelessly, Joe.
Well, there were a couple months there where lots of legal briefs going back and forth. But yeah, it's been that has been the most interesting and most intense dispute, because it's just the dispute has both parties have gone to lengths to use the different processes of the Federal Labor Relations Authority to to prevail in this dispute over whether the agency can bring back teleworking employees into the office. And that it's a pretty deep question, and there are some conflicting principles of employment and labor relations and labor law that somebody's going to have to decide at some point. And it looks to me that that's probably going to be the incoming president and the new Congress. Um, it seems like they have their eye on teleworking federal employees, or maybe just federal employees altogether. So the dispute might be, all these disputes might be mooted when the incoming president comes in and he and Congress act, because Congress has the ultimate say over, the rules for federal employees, because they write the laws that give federal employees their rights. Any other questions?
Hey, Joe, it's Nina.
Hey, Nina.
Hey, you kind of answered this in your previous question, but I would love for you to share, just so everyone kind of gets an understanding, in your role at DOL, through FYI. So it's kind of a multi-part question. I know you have gone to arbitration for different things, and so generally, but in your role, you are supporting the agency view. You're not supporting the employees, right? You're usually handling it on the Department of Labor side.
That's correct. I represent management,
Mhm.
and if the employees and management may be aligned on an issue, or they might be, opposed on an issue, but my job is to represent management's view, regardless of whether others share that view.
And are you able to share with us, so you outlined the process really well. Thank you for that. I'm curious to know, maybe you can share with everyone how often in your experience, right? Is there, are you able to resolve before arbitration in most cases? I know you've traveled specifically for that, but how often are you actually getting to that point, and how often are you able to resolve things in an earlier step of the process? Maybe if you want to just talk a little bit about like your own experience and what you've seen at Department of Labor.
Sure. So most disputes do not end up at arbitration. Arbitration is very expensive. Arbitrators, the private judges, that's how I think of them. They charge quite a bit of money, thousands of dollars per day to deal with your case, and the union has to pay half of the arbitrator's fees, so they have to be willing to put out quite a bit of money if they want to take any given dispute to arbitration. It's a lot easier for the agency because the agency has much deeper pockets than the union. So they don't need to worry about finances the way a union might. But aside from the cost issue, I would say that most grievances that arise at DOL are from employees over their individual performance ratings, or they got suspended for something and they disagree with the reason, or they think the suspension was too long, so they grieve their discipline. And much of the time that won't end up going to arbitration. Maybe cost is a factor in the union's decision not to take a case to arbitration, but it's ultimately up to the union whether to invoke a matter. Arbitration is the culmination of the grievance procedure. And so, an employee will file a grievance, they get, they have a hearing, and then they can appeal from that hearing. And if they're still not happy after the appeal, then they can invoke arbitration. So during the first two steps of that, most grievances are resolved. And I guess being resolved includes just like the employee accepts the outcome, even if they don't like it. Does that answer your question?
Yeah, thank you, Joe.
Sure.
I know you're going to have 2 follow-up sessions after this, to dive into more details, so I'm looking forward to those. Thank you.
Yeah, me too. Thank you.
Well, thank you so much, everyone, for joining us for this session. Thank you so much, Joe, and we look forward to 2 more sessions.
Yeah, sounds great. Thank you, Nina. Thank you, Anya. And thank you, FYI. And thank you, everybody on the call. I appreciated this opportunity.
Thank you, Joe.
All right. Have a good day, everyone.
Thank you so much.
Thank
Have a good day,
you.
everyone.